And this ordinance will be promulgation or will be executed since 2015, and all the teachers from their service must have TET eligibility. So you can say Supreme Court has given this order on the testimonial of this ordinance.
Now, Supreme Court, one of the main contentions that we will be raising is that the Supreme Court has given retrospective effect, which was not the intention of that ordinance also. And the Supreme Court, in its own recent decision of the 9-judge bench of the Supreme Court, has said that once the appointment process is started, it cannot be later changed.
Okay.
Now,
once the game is on,
the rules cannot be changed.
Okay.
Now, if an additional requirement is brought at the later stage, it can only apply to whoever is being appointed after that.
Okay. Yeah.
And whoever is being appointed to pursuant to an advertisement taken out after.
It should be prospective.
And therefore, it cannot be made. In fact, if we look at the cases which were there before the Supreme Court also, and which had come from the respective high courts, the question over there was applicability of TET prospectively to minority educational institutions.
Okay.
And it was never the intention, or it was never the scope of the adjudication in the High Court as to whether they should be applicable on a retrospective basis and whether it should be applicable to all other schools on a retrospective basis. So therefore, that is one of the main contentions.
142 has been used. You can say the teacher serving, it is very oxymoron to say and will be very unnatural according to the law of the natural law. A teacher having age 56 years 11 months, he is just he has to clear the TET exam, whereas the teacher who has just crossed 57 years will be free from the TET examination. It is something that Supreme Court has actually used 142 for just pushing this all things, normal things to really resolve.
No doubt the Supreme Court has wide powers under Article 142. However, there are a number of decisions of the Supreme Court itself which have said that the power under Article 142 should not be used to override any right or any sort of statutory provision.
Okay.
And it should be applicable only where there is some sort of ambiguity or some sort of doubt.
Okay.
Over here, what is happening is that there is a vested right of the teachers who have been appointed prior to the application of this ordinance or the rules.
Okay.
And it is those rights of those teachers are also being today made subject to the new order which is now under challenge. So I would say that, and in fact that is one of our grounds before the court, that Article 142, the applicability of Article 142 should be restricted only to the prospective aspect and not the, it should not be given retrospective application.
Where do you find some field or some space that where we can put our review? As Supreme Court has mentioned that the teacher who is not having the TET eligibility have imparted their best of the education to their respective child, and they are really signing in their respective career. We could not ignore, we could not aside such talents. But when Supreme Court says that I will have to take some hard decision that all the teachers having service more than 5 years must have TET eligibility, we find something that some space are left that we can just put our counter and our parts that is this something that teacher before 2010 should be free from TET.
Now this wider question of whether a teacher is imparting good education or not is something that is far more fundamental, and perhaps I cannot go into it at this stage. But this definitely we can say that all the teachers who are today affected by it, they are all qualified in some manner. In their respective advertisements, and a large number of these teachers have also obtained qualifications that were recognized and approved by the NCTE itself.
Okay, yeah.
And today we are now looking at a situation where at one point of time NCTE themselves said that this is the qualification you need to take. And they took that
eligibility,
and today we are telling them that no, that is not sufficient, you have to do something else. As to the workability of it, now the teachers who are in service for so long, they are now being told that they now need to take a new exam and new qualification.
It will be very hard for them.
There will be some teachers who would have to undergo a fair amount of training even to take that qualifying examination. Now, and it is required that they do this within a period of 2 years. As to whether it is even implementable or not, that question is looming large, and I think for that reason it should be reconsidered on the footing that it be restricted only on a prospective basis.
Okay. We find that teacher who has been recruited in 1995, the 12th and the BTC was the you can say saturated eligibility.
Yes.
In 2004, in 1999, in 2009, the respective advertisement that the teachers who has appointed has fulfilled.
Yes.
But now how can you say that an eligibility test? Supreme Court has given order that an eligibility test will just figure out as a mandatory thing for all the teachers. It is just eligibility test. Teacher appointed as 23rd since 23 August 2010, it has been executed. Then how can it would be a universal mandatory thing that all the teachers prior to the 2010 and later on must have? Do you think that Supreme Court really figure out that TET is a mandatory and universal eligibility as all the academic qualification is?
I would agree as to the mandatory aspect, but we cannot agree as to the universal aspect. Today we are not getting into the question of whether it is a desirable thing or not. We are saying that to the extent that it is made applicable to appointments made after it was brought into force, we are not getting into that. We are not opposing that.
Yeah.
Let it be implemented for the new recruitments.
Okay.
And let it be made mandatory for the new recruitments also.
Yeah.
But you cannot today set the clock back.
It was implemented.
And yes,
it should be covered. Something that so interpretation has been made that in the ordinance that has been passed the central government in Article 23rd to subsection 1, two subtitle has been mentioned, and in one subtitle the trained teacher. It has been said trained teacher. It is not said the TET. The respective states who is not having some training institute must train their teachers, all the teachers that has been covered in their state. And in other para it has been said that the teacher, the government also provide, the central government also provide 452 crore for the teacher that should be trained until 2019. It has been said. So, do you think that our counter, our respective counter, has was not there when all the encounter of Tamil Nadu and Maharashtra has been going on? The counter has not been, the counter was not there, and to say that the 23 article 23 second has some issue to be really figured out.
Yes, we were not party to the proceedings so far, and it is only now after the order that when we are feeling.
No any notice has been issued.
No notice had been issued to us, and therefore we did not have an opportunity to place our contentions before the court. Now that we are coming into this, these are some of the aspects we will be placing before the court and seeking that the court now modify its order to ensure that all the rights and interests are balanced. From another perspective, we can also show before court that what is the intention of this ordinance, and let us even put it in a constructive and purposive fashion, that why is it that this was brought in, why is it that the requirement of TET was brought in,
okay,
that what was the situation historically before 2009. Today all the teachers whom we are representing, they are all teachers who have some kind of qualification, but prior to that there were many states where there were persons without adequate qualification, without the necessary training, who had been appointed on contractual basis or temporary basis.
That's why I said trained teacher. Yeah.
They had been appointed. Now it was to ensure that those persons are also brought onto some form of formal teachers training. The purpose of RTE was that there should be someone, there is some sort of standardized qualification process who will be able to teach the syllabus as prescribed in a uniform manner across the state. So for that reason, that is the reason that there was some sort of mandatory training that was brought in. This does not mean that everybody who was appointed before that mandatory training did not have the necessary qualification at all. Whatever qualification was there in a recognized fashion, the teachers who are before court today are having, and we would stress upon this fact that it is not that these persons are untrained teachers just because they do not have the TET qualification.
आरटी एक्ट में भी तो ये दिया गया है कि ये आरटी एक्ट लागू होने के पहले के जो टीचर्स हैं उनके ऊपर
रेट्रोस्पेक्टिव
नहीं होगा तो वो फिर ले आकर के कैसे वहाँ इसको
जनरलाइज कैसे कर दिया, इससे सामान्यकरण हो गया एक तरह से आदेश को आप देखेंगे तो इस आदेश का सामान्यकरण इस तरह से हो गया। हम सारे बिंदुओं पर जाते हैं, लेकिन उसमें जब ये देखते हैं कि 5 वर्ष से अधिक सेवा, जब ये लाइन आती है तो उसमें सारे हमारे इंटरप्रिटेशन मिस आउट हो जाते हैं। अच्छा सर, इसमें मैं ये कहना चाहूंगा, एक्चुअली वन थिंग दैट आई वांट टू मेंशन दैट एज द सुप्रीम कोर्ट हैज ऑर्डर्ड, this is the first time you can say 9.8 million teachers across the country has been affected. The number is huge. It is a matter of livelihood. And yes. Supreme Court, as far as Supreme Court is concerned, Supreme Court has never given any order that really not beneficiary for the people. And the last people in the country has been benefited by the Supreme Court. Supreme Court is also known for the really secure the loyalties and the fundamental rights of the last one people of the country. Do you think that this number is very huge? 9.8 million teachers has been affected and their livelihood is concerned. So the petition and the review, all the encounter that is going to be made, I hope, and from your parts I want that some assurance that how would you go through to the court?
So of course we are completely mindful of the fact that there is a large number of persons whose livelihood is at stake, and we will definitely be placing this concern front and center before the Supreme Court when we place our review petition or any of the other petitions that will be filed on behalf of the teachers. We would also take an approach where we are making it clear that we appreciate the intention of the Supreme Court where they want to ensure that the best quality education is imparted to the students of this country. The impact of 9.8 teachers being suddenly removed or being their promotional avenues being stopped would mean that a large number of schools would stop functioning across the country, and there would be the respective states and the state boards who would be placing their concern before the court and saying that If so many teachers, so many teachers are removed at one go, how can I run my schools? And what will be the impact of education on that? So while the Supreme Court has very good intentions of protecting the students and ensuring that they get the best quality of education, this order may have a counterproductive effect on that intention, and we would want to place this before the court and work in an assisting and constructive manner along with the court to best reach the goals that the Supreme Court has very laudably set for itself.
Okay. Now we are heading towards the submission of the petition and as well as the review petition. So it would be submitted today?
Yes, it will be filed today.
That is all for here, and we are having the most prestigious counsel from the Supreme Court, and we are very assured. हम लोग के साथ हमारे आदरणीय संरक्षक
नमस्ते
देवेंद्र प्रताप सिंह MSU में
देवेंद्र प्रताप सिंह जो एक चेहरा है प्रदेश ही नहीं देश का भी, जो उम्र भले ही आपकी है लेकिन आपके अंदर जोश आप देखिए ये